Hi, my name is Corey Biazzo, and I'm a practicing American civil litigation attorney, and you are watching Executive Coup, Episode 2. In today's episode, we're going to unpack some of the legal issues surrounding President Trump's Birthright Citizenship Executive Order number 14160, titled Protecting the Meaning and Value of American Citizenship. As mentioned in the prior episode, oral arguments are scheduled in the U.S. Supreme Court on this case on May 15, 2025. Section 1 of the 14th Amendment of the U.S. Constitution states in part, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Until you get to the phrase subject to the jurisdiction thereof, it seems apparent that any person born in the United States is a citizen of the United States. Pretty simple, right? But what does subject to the jurisdiction thereof mean? Well, as you may be aware, the term comes from the common law or case precedent. Like the country's origin, American common law traces its roots in English common law. Back in medieval times, when England was solely under the rule of a king, the English common law dictated that all persons born within the king's allegiance and subject to this protection were English citizens. In modern day speak, this means any person that was born within the physical kingdom of England was an English citizen. And of course, this common law carried on from England through the colonies and into the United States that we live in today. All people, included all people, even the children of foreign nationals, regardless of their particular status in England. The only exceptions were children born within the kingdom to foreign diplomats and children born to hostile foreign invader occupiers of English territory. The logic in regards to the children of foreign diplomats was that while they were physically born in England, they were born to parents who were in England while acting in the service of a foreign nation. The logic in regards to children of foreign hostile invader occupiers is that while English territory was occupied, it was not under control of the jurisdiction of the crown at the time of those children's birth. Moving forward in history, the 14th Amendment to the U.S. Constitution was ratified after the Civil War as part of the Reconstruction period amendments. The primary intention of the Birthright Citizenship Clause of the 14th Amendment was to right the wrong of the Supreme Court's infamous Dred Scott decision, where it held that an American-born slave was not a U.S. citizen. However, at the time the 14th Amendment was ratified, it was understood by Congress that the amendment was simply intended to codify into the Constitution what the American common law already held regarding American birthright citizenship, which flowed from England. This meant that anyone born within the physical United States is a U.S. citizen. By codifying that long-standing principle of birthright citizenship that flowed from England through the colonies and throughout American history until the time it was added to the Constitution, Congress provided a strong guarantee for all people born in the United States, including newly freed African American slaves. This opinion was confirmed by the U.S. Supreme Court in 1898 in a case named United States versus Wong Kim Ark. In that case, an individual named Wong Kim Ark, who was born in the United States to parents from China, was denied entry to the port of San Francisco after returning from a trip visiting family in China. This was at the time of the Chinese Exclusionary Act. Wong Kim Ark sued the U.S. government, where the court ultimately affirmed that Wong Kim Ark was in fact a U.S. citizen because he was born in the United States, notwithstanding the fact that he was born to Chinese national parents. Today, the President's executive order seeks to narrow the scope of birthright citizenship to exclude individuals born in the U.S. to parents who are foreign nationals that were unlawfully in the U.S. at the time of birth or only temporarily in the U.S., such as on travel visa. However, the president lacks Article 3 power of judicial review to interpret the meaning of the law. If the president wants to change the law, he needs to consult with Article 5 of the Constitution, which deals with amendments. But because he hasn't done that, and that because the power of judicial review is only bestowed on the federal courts under the U.S. Supreme Court, the president lacks the authority to issue a valid executive order redefining birthright citizenship. Therefore, the president's executive order is unconstitutional because it violates the 14th Amendment and because the executive order violates constitutional separation of powers. For more information on this case and others related to the apparent executive coup in the U.S. government, check out future episodes of Executive Coup.